Hi everyone, welcome to Litigation Help. My name is Heather and joining me today is Dan Rosman. So today we're going to talk, I'm going to ask Dan to give us 5 tips for people who are representing themselves who want to start a claim, who want to be suing someone. So Dan, can you give us some tips for, I guess, self-represented plaintiffs is what they're called?
Right. So a plaintiff is the party that wants to bring a claim, right? So they're the person that has a dispute with someone else or a business, or they might be a business that has a dispute, and they want a court to adjudicate that dispute. So the first thing that I would suggest someone who wants to be a plaintiff should do is figure out what is the problem that I have and where should I go to get it sorted out. Right. So a landlord, if you have a problem with your landlord at your home, right, you can't go to Superior Court of Justice to deal with that in most circumstances. You have to go to the Landlord Tenant Board. If you have a claim against a defendant for less than $25,000, you should be going to Small Claims Court. If you have a claim over $25,000, you should go to Superior Court of Justice. If you have a human rights complaint, you might have to go to the Human Rights Tribunal. So the first step, I think, would be to figure out what is the nature of your claim and what is the correct venue to have it solved. Right?
That's interesting, yeah.
So that would be my first tip for a self-rep.
You have to know which court to go to.
You have to know where to go because you'll be thrown out the minute the judge or whoever it is finds out that you're in the wrong place.
Is there like a book or a website that can kind of like outline which court hears which disputes?
I'm not sure if there's a specific website that does it, but I think if you spend some time looking online
it's possible
you'll find out
the information.
Right.
Oh, okay. So do you have another tip for us for the plaintiffs?
So one of the things that I would recommend to plaintiffs is to check limitation periods.
Oh, right.
So there's a lot of different limitation periods hiding all over Ontario law, right?
Hiding?
Hiding.
Okay.
There's a Limitation Act, which sets out the majority of limitation periods in Ontario. So that usually sets them for 2 years. Sometimes it's 10 years, depending on the nature of the dispute. That means that when you knew or ought to have known that there was a claim to be made, you have 2 years from that moment to bring your lawsuit. So sometimes a potential plaintiff might say, oh, remember that bill that wasn't paid at my office 15 years ago? I'm going to sue today. Well, you can't. You can, but there's a defense open to the defendant to have that taken away. Yeah. Now, to take it one step further from limitation periods, there's also civil procedure deadlines. Right?
Okay.
So you have a certain amount of time from when you file your statement of claim to when you serve your statement of claim.
Right.
If you're a defendant and you get a statement of defense, you have 20 days to respond to that statement of defense. So there's a lot of limitation periods and procedural deadlines that, again, I'm going to say are hiding all over the place that you have to be aware of. So a tip to self-represented litigants is to really pay attention to those and find out all the ones that apply to you.
Oh, wow. So is it easy to find all this stuff on the internet, or maybe you could consult a lawyer? I'm almost thinking maybe...
I don't want to say it's easy or hard. I mean, I've been doing this for a while, so I have an idea of where to go and look.
Right.
But I think it might be difficult for someone new at this to find those all out. But the rules of civil procedure have them, and asking a lawyer would definitely be a good idea.
So this limitations period thing that you mentioned is really interesting, because I know a lot of people mistakenly think that everything is 2 years.
No, that's incorrect. That's not true.
So you're saying that there are a lot of exceptions.
There's a lot. So I'll give you an example. So at our office, we do defamation. Right. So there's in the statute that governs defamation, libel, and slander in Ontario, there's deadlines in there about when you have to serve certain documents, when you have to serve a notice of libel, when you have to start your case after the notice of libel has been served, which is way less than 2 years. It's 6 weeks, 6 months. It's all different timelines.
Oh my gosh.
So if you are a self-rep and you want to bring a defamation claim, you should check the Libel and Slander Act, because it's going to have deadlines that are very relevant to you in there.
So it's not just the Limitations Act that you have to worry about in terms of statute. You have to actually know which statute even applies to the nature of your complaint.
And then there's other limitations in the rules of civil procedure as well.
Right.
So an example is there's a 5-year dismissal period. So if you bring a case and it's not finished, it hasn't gone to trial, hasn't been adjudicated in 5 years, it just gets thrown out.
But can't you argue to the judge saying you have a reasonable excuse?
Absolutely. And you can bring a motion for that and all that stuff. But if you don't, and you don't know about that 5 years, your case is gone, you don't even know. So the point is that there are these deadlines lurking and hiding everywhere, and it's very important that you're aware of them.
Oh my gosh. Do you have anything else to share with us today? Because we went through which court to go to. That's important. We went through deadlines.
Right.
Hiding, and do you have any
another thing that I've seen a lot, and I'll just use the broad topic of following the rules, right? So we talked about the rules of civil procedure in another video. We talked about the practice directions in another video. Those rules are very important to follow, and a tip to any self-rep is to make sure you are fully aware of all those rules. An example that I can give is service, right? So service means that if I have to deliver a document to the defendant or to someone else, I have to swear an affidavit that says it's been served. Handing it to that person or delivering it to them in whichever way you're allowed to do is called service. So you have to prove to the court that you served documents a lot of times before you file it. So I've seen self-represented litigants show up to the court office on the last day of a deadline to try to, let's say, file their statement of defense or the materials for their motion, and it gets rejected because they haven't followed the rules, they haven't had an affidavit of service signed, and they might be too late on deadlines because they haven't done that. So my final tip would be just rules, know your rules, know what you need to do, and do it properly.
That's amazing. Well, thanks so much, Dan, for these really helpful tips. And thanks for watching. See you at the next video.